All right, hi everyone, how are you? This is Monica here with the Best Interest of the Parent. I'm no longer Moms Unshackled. I have since changed my business name to the Best Interest of the Parent about a month ago. So if you are seeing me for the first time, you want to make sure you're in the right place, right? So if you are just getting to know me here, I do these live Q&As every once in a while. I just pick out like the most common questions I'm getting and I answer them live here in the group. So I'm typically here every single Monday night between 8:30 p.m. Eastern and like 10 p.m. Eastern, however my schedule works out that day. And I lost all my notes because my computer's not working. So I'm going to ad lib tonight with my responses to your questions. So let's see here. If you are, like I said, if you're just coming in for the first time, you are probably a family court parent, a loving mom or dad who has seen your life ripped out from under you when your ex sued you for sole custody. Perhaps you have already lost your children, or you lost substantial rights to your children. You've lost property, you've lost dignity, you've lost a lot, like maybe your reputation, your job, your home, even relationships with your friends and family, your health. So there's a lot of losses, right? Like you've really just been hit with a lot of heavy losses that you weren't anticipating. And that can create a lot of negativity, self-doubt. It could breed autoimmune disease. It can cause mental illness, and it can have you in a perpetual state of shock. And that is very hard to overcome when we don't have professionals that really understand what we're going through. Like when you go to therapy, no one really understands this particular type of trauma, this government-sponsored trauma, because the system is corrupt. And it's really difficult to put your life back together and even know where to go. Like, how do I put my life back together? Do I just take medications for my symptoms? Do I, walk away from my court case? Do I just save up tons of money for an attorney? Do I, liquidate my home? Do I liquidate my 401k? Do I ask my parents to sell their house? What do I do? Like, how do I recover from this? Do I just become zen about it? And oh, here's my computer working now. Hang on one second, guys. Sorry. Here we go. Okay, so yeah, so what happens is, what I have found after working with parents for all these years, I started working with parents in 2016, and I have found that when a parent embraces an activist mindset and makes that shift from being a victim of the system to being a warrior and someone who's going to fight for reform and justice, then they are the ones who do better than the parents who save 50 grand and blow all their money on another attorney and continue the litigation and the abuse. And so what we're missing as parents is we're missing empowerment, and we are also not sure how to properly take care of ourselves in the system. We don't know how to take care of ourselves because the narrative in family court is to fix things. You just need to go to co-parenting counseling. You need to just go to therapy, submit your own therapy records to the judge, show the judge that you're better. Like we tend to work inside the system, buying our way out of problems as a way to fix things. So my messenger, geez, it's like blowing up. So we tend to start spending more money in the system to buy our way out of the problems. Parents haven't really understood that they need to retract from spending money inside the system to get better and just work on their own healing template. So that's where I come in. I'm a certified health coach. I'm a mindset coach, and I'm on my way to becoming a certified life coach. I still have quite a bit of ways to go. So I'm not a life coach yet, but I'm working on it. So anyway, we're going to get right to the Q&A session here, and let's see what my questions are today. I'm so sorry I lost all my notes. Hang on, let me see here. I'm going to go by memory. I believe one of the main questions I was going to answer tonight was what to do when somebody submits to a psych eval or a custody evaluation. Their attorney gave consent on their behalf, or they gave consent not knowing what was going to happen, like not knowing how deep this was going to go and what the ramifications would be. But you've already given consent. So what do I do? I've already given consent. I can't ask this to be changed because I already said it was okay to do this. I already gave consent. How do I take back consent? Is it too late? Do I have to keep on submitting to this process? So why would a parent want to give consent in the first place? Guys, I am so sorry. I left my juice on the other side of the room. I'm such a mess tonight, I swear. Hang on. Today marks day 30 of a juice fast that I'm doing. I haven't had any solid food since December 12th. This is apple and parsley juice. And here we have, I don't remember, this is apple, I think this is pear and orange. So anyway, I'm going to be sipping because my throat tends to get dry. So why would a parent want to have a psyche eval in the first place, or any sort of evaluation? Well, they think that they have no other choice. They think that, you know, their attorney makes them believe that they need to submit to this process. And the parent thinks that they just have to do it. Like, oh, I have to show that my child is not doing well in school and that my child needs to spend more time with me. So I need to bring in a third party to evaluate my child's report card and talk to my child's teachers and the school psychologist and the principal and, you know, my next door neighbor and like my next door neighbor's dog, so that the judge can see that my child's not doing good in school. Because I can't bring in my kid's report card and point to the freaking letter F on the thing and the D and the needs improvement in this area. I can't do that, right? I need to hire someone to do that. No, absolutely not. So this is my opinion here. Nothing I say here is legal advice, but I've been in the system. I'm going into my 12th year. I've officially entered my 12th year. And from what I've seen and what I've observed, reading hundreds of cases, talking to probably 1,000 parents at this point, maybe 2,000, I have never seen any evaluator contribute anything of value to a family court case, because from what I understand about the law, there's no reason why a litigant can't hand that exact same information over to the judge. Like, why can't person A or person B submit this information? Why does an evaluator have to go and do that work when the parent can just do it? So again, these evaluators are just here to bleed money out of you. And if they are working for the state, then they are here to bleed money out of taxpayers. So either way, the act of having an evaluator is nothing more than just a revenue generating piece of the machine. And there's nothing that this person can possibly contribute. So a parent doesn't know often that they don't have to agree to these things. These things are always voluntary. So your attorney will probably tell you that you need to do this, or the judge will say, I'm gonna appoint an evaluator, blah, blah, blah. But the parent can always say no. So if a parent isn't objecting, that is considered consent. In the family court system, silence is consent. Understand that. If you're not opening your mouth and saying no, it's a yes. It's the exact opposite of like a date rape scenario, where, you know, if the person doesn't say yes, it's not consent. I don't know what the rules are, but it's the opposite in family court. I've said this before. If you're walking down the street and someone starts attacking you with a baseball bat, if you don't say no, don't hit me with that baseball bat, would that be considered consent? If you just start screaming and you call 911, you know, by the family court standard, that is still consent, because you didn't say don't hit me with a baseball bat. But anyway, you have the right to say no because you have Fourth Amendment rights to be free from government searches. And an evaluation is a government search. It's a search and seizure into your life. It's a seizure of your records, your medical records, your child's report cards, school records, all sorts of things. And the parent can say no to these things. So what happens when a parent gives consent and or the attorney gives consent on the parent's behalf and the parent isn't aware? There's two parents that reached out to me that are going through the exact same situation, and the parent is now like, oh my God, what happened? Like, now I have to do this thing. So again, this is not legal advice. This is my interpretation of the law. If you're in a situation like this and you really don't want to go forward with the evaluation, then it would behoove you to call up a civil rights attorney, an attorney that understands the Fourth Amendment. You can check out that attorney's website and make sure that it says like Fourth Amendment law on it. You know, I don't know if they will publish that information, but a civil rights attorney would know. Another thing you can do, and I'm going to talk about scholar.google.com later. Another thing you can do is research scholar.google.com for your state and find out, type in the words Fourth Amendment and find out if there was an appeal that prevailed on a Fourth Amendment argument, and then find out who that attorney was that argued the Fourth Amendment. So that's another good way to like pre-screen an attorney. And this is if you don't want to spend $250 to vet people. So I believe, and if you have a lot of money to spare, or you're limited on time and you don't have time to research, you can just interview, three attorneys and pay them their hourly rate. It might be like $250 an hour, $300 an hour. In my opinion, you're better off paying for that hour than submitting to the long-term evaluation, because even a free evaluation is expensive later on, and I'll explain why. If I remember, I'll explain why a free evaluation is still very costly. So if you can interview three attorneys on what they know about the Fourth Amendment, how to get out of a search, how to rescind consent, how to revoke consent, then I would do that. You're better off spending the money and time talking to an attorney about that. And again, you can research scholar.google.com, and you can pre-screen attorneys that way. And I recommend getting a case that's like 3 years old or less, like 2018, in that range, and find out, explain the situation, be like, my other attorney gave consent on my behalf, or I gave consent not knowing what I was giving consent to, and say that this was not a knowing and intelligent waiver of my rights. You could say that this was not a knowing and intelligent waiver of my rights. I didn't know that I was waiving my rights when I did it. I didn't have all the information. I signed the forms, because oftentimes the parents will consent and then they'll get called by the evaluator, and the evaluator will give a bunch of details about what the evaluation is going to consist of, and the parent's like, whoa, I didn't freaking consent to that. Like, that's not what I thought it was going to be. That happens all the time. Family courts are intentionally vague when they try to get parents to give consent. They give as little information as possible. I have a parent that I was in touch with yesterday who apparently, all this was like done over the phone. Like, how do you give proper consent when you're just in the middle of a phone call 5 minutes before court closes type of hodgepodge deal? And this is a very, evaluations are very, they have a lot of impact in your case, and they heavily invoke your Fourth Amendment rights. So there's a lot of stuff here at stake. This is not a simple thing like mom agrees to pay half the doctor bill where you're only out $400 if you screw up. This is a really big deal. Sometimes parents will accidentally consent to like giving up summer vacation. This isn't summer vacation. This isn't a $400 doctor bill. This isn't like, this is not even as serious as like choosing a school, because choosing a school, that doesn't necessarily impact your fundamental rights. A custody evaluation or a psych eval has significant consequences in your case. It carries for a very long time. I had an evaluation in 2010, and every time I go to court, the judge still opens up that evaluation and reads opinions from that evaluation to generate new opinions. And so they do this. They say, well, in 2010, this evaluator said this about Monica. If it was true in 2010, it must still be true. And the residual effects of my evaluation from 2010 are still hurting me to this day. And so I knew I was going to talk a long time about this. So if you find that you don't want to go forward with this, talk to some attorneys, find out how to revoke consent. I believe it's, again, not legal advice here, but I believe it's far easier to rescind consent for a psychological evaluation than it is for a regular family evaluation. And the reason for that is because of the Patient's Bill of Rights, informed consent rights, all sorts of things. You have more medical protection when it's a psychological evaluation. Because listen, if you call up a doctor, and any doctor, you have, I don't know, you have a heart murmur. You think you have a heart murmur, you want to go get checked out by a doctor. You can call up the doctor, make an appointment. Okay, I'll see you Thursday at 2. You could go there, you could park your car, you could walk in, you could sign in at the reception, you could submit your insurance card, you could sit in the waiting room. You're still giving consent, right? You go down the hall, you go into room 304, you sit there and you wait for the doctor to come in, the doctor walks in. You're still giving consent. You can literally change your mind right then and there and say, you know what? I decided I don't want to go forward with this examination today. I'm gonna cancel the appointment. You might get hit with a $50 cancellation fee. Who freaking cares? So here's the question for you, and this is a question to ask an attorney. And if you're going pro se and you want to back out of this, you can you can, this is not legal advice, but you can file a motion that says, I'm giving notice to the court that I'm rescinding consent for this evaluation because I have rights under the Patient's Bill of Rights. I have rights under informed consent. And if a person who is not in family court can cancel an appointment, hang on. If a person who's not going through a divorce and is not in a fight with their ex over bullshit, if they can cancel an appointment at any time, why can't I? Why do the laws apply differently to me because I'm in family court? You can say that. And so the 14th Amendment demands equal protection of the laws. And you can also say, not legal advice, you can also say, I have rights under the 14th Amendment. The laws apply to me just as equally as they would apply to anybody else who's not in family court. I'm not any different than Joe Schmo down the street who's making appointments with his dentist and wants to cancel. So, I mean, I would say all this. Who cares? Like, I would totally say that. So I should be able to back out of this also, even though I gave consent. So you can take that angle if you want. You can, now if this is a regular custody evaluation and you're like, oh crap, I gave consent, I don't know what to do now, you can still attempt to revoke consent because it, and I don't know what the laws are with revoking consent. I don't know if they change by state. That's something that you'll have to research. But it's also worth calling up an attorney and asking, how do I get out of a government search? I consented. How do I revoke consent? You can cite that you have since learned your rights and you want to take back consent because this was not a knowing and intelligent waiver of your rights. There is some case law. You'll have to research it on your own with scholar.google.com and find out what case said that waiver of fundamental rights has to be knowing and intelligent. And or you can read Ron and Sherry Palmer's book, Not in the Child's Best Interest. They might have that case in there. It's worth getting that book anyway. Like almost all my students have that book. I just give it to them because I like my students. And so I would do all of that. Now, if you find that this is too treacherous and you're like freaked out, like you're like, I don't know how to file motions, I don't want to pay an attorney, I don't want to do this, I don't want to do that, you can go forward with this evaluation anyway. And what I would do, and everything I'm saying here is just what I would do. I'm not saying you should do this, you should do that. Like, I'm not doing any of that. Do make your own informed decisions. What I would do if I were in an evaluation that I couldn't get out of, well, I would pull consent. And for me personally, I would just not comply. Like, I would just not do it and say, I don't consent to this, I don't consent to this. But if you're not in a frame of mind where you're willing to do that, if you have like a 2-year-old kid that you're in court for. See, my son's 14. So I could be anybody I want in court now because I know that even if they take my son away, my son's still going to find a way to contact me. Like, he's 14. And so it's easier for me to be like a little bit more punchy than someone with like a 3-year-old or a 6-year-old. You might not want to do that because if you lose access to your child because some judge is a dick, even though you could appeal that and win, you're still going to lose 2 years with your child in the appeals process. Where for me, I'm prepared to have my son taken from me at this point because he's of his age and he will find me. He'll just call me if he wants to. We could FaceTime. Like, we'll find a way to hang out. That's where I'm at. But when he was first taken, he was 3 years old. So what I would do now in 2021, I would not have done 10 years ago. My son was in preschool when he was taken from me. So you can just not comply depending on where you're at in your case. But if you want to comply because you don't want your child to be taken out of retaliation, you can go forward with the evaluation, and you can tell the evaluator every single time they ask you a question to be like, I appreciate you asking this question. I know you're just doing your job, but for me, I know that anything I tell you can be used against me, and I'd rather not answer that question. So you can consent to the evaluation. It doesn't mean you have to answer every single question. So you could give like name, address, phone number. That's the evaluation. They evaluated me. They know who I am. They know I'm the mother of this child. They know I'm the father of this child. They know that I was married in 1994, and they know that I got divorced in 2008. Like, you can just give that information. It's almost like if you're I think they say if you're in the army and you get captured by the other side, you could give your name, rank, location, and that's it. Don't tell anyone where the nuclear missiles are. So it's kind of the same thing. Like, don't tell them anything, just name, address, height, weight, birth date, and that's the evaluation. Like, there's no, like, you get to decide how much of your information you're going to give to the government. Like, you could still use your Fourth Amendment within the context of the evaluation, and it's going to piss everybody off. But I personally, like, I think you're better off using your rights and preserving your rights in this evaluation than you are just giving everything away and having things go south. But do weigh out your decision. Like, weigh this out, because you're not supposed to get punished for using your rights. The Supreme Court has made that very clear. I think the case is Shapiro. Look it up. You'll have to verify what I'm saying. But you can argue that you have the right to use your rights. And even though you agreed to this evaluation, you can just, do like a rudimentary compliance with this evaluation, make it really boring for them so they have nothing on you. And then everybody's going to get mad, like, oh, you're supposed to share this, you're supposed to share that. But you can say, oh, I really don't feel comfortable sharing that because I'm in a custody dispute and I don't want to lose my fundamental rights to my child. If you just say that over and over again, that is the evaluation. Like, they evaluated you. Your perspective is that you don't want to lose your rights, you don't want to give away your information, this is a government search. That's just what I would do. I would either do that or just not comply at all. So I hope that helps a little bit. Let me get into, there's a piece I wanted to cover. So if you do agree to the evaluation because you're too exhausted and frustrated with the process to like do legal research and stuff, and you just like totally give in, it's still really expensive to have this done, even if it's free. And the reason for that is because this person that's evaluating you is going to be a major part of your litigation for a long time. And so anyone that you hire is going to have to talk to her or him. It's always a short-haired, bitchy, worker. So her is usually, it's a her. So you can, if you hire an attorney in 2 years, they're going to be talking to this evaluator a lot, and then you have to pay your attorney to talk to that person. So even though it's a free evaluation, you're still going to pay hundreds and hundreds of dollars just to have that person in your case. It's still like a billable piece of your case. And then also, while you're in court and they're testifying, and if you ever want to get transcripts, you're going to have to pay for all the bullshit they're going to say on the stand. I mean, if they talk for half a day on little Johnny going to the playground and hurting his knee and wanting his mommy, this is the kind of stuff they talk about. Who cares? Like, it's just not important stuff that they do, and you're gonna have to pay for them to speak, because you're gonna have to pay for your attorney to like cross-examine them. Like, there's just a lot of expense involved just by them being there, just by them taking up space in your case. It's billable expense, and it's going to be a headache. And anything that they publish, you're gonna have this big report, you're gonna have to hand that off to all these attorneys that you hire. It's going to be a part of your record, so if you ever have to copy your record, you have to pay for all those copies, like $1 a page. So I just found that the more people that are in your case, the more space they take up, and the more like oxygen they take up in your case. So I just think the less people in your case, the better. I personally think a custody case should be mom, dad, mom's lawyer, dad's lawyer, and that's it. No freaking third parties, no therapists, no evaluators. If you want to go to therapy, but they don't need to be involved in your case, in my opinion. Your child's therapist, like, I don't understand why everybody wants to bring in the Jeffersons into their court case. Like, why are there so many people in your court case? Like, it's not that difficult. If your child's being abused, go to CPS, go to the police. But anything else, like, why do you need to have all these people in your freaking court case? They're useless. These are useless mofos. And that's just my 2 cents on all that. So that was a really long response. I'm so sorry. So I did talk. So one of the questions I had was how to use scholar.google.com. Personally, like, I'm going to try to give the best answer. I just screw around with it. I just type in all sorts of stuff. I mean, I don't have a special way of doing it. So my advice to you would be to seek out the assistance of an appellate attorney and hire them for an hour. Like, what appellate attorney doesn't want to get on the phone with somebody for an hour, make $200 or $300, and just do easy stuff like tell someone how to use scholar.google? It's just, I can't imagine an appellate attorney not taking advantage of that. Like, these are attorneys that are chasing down their clients for outstanding balances, and why wouldn't they want to make a quick $300? I think it's worth the investment. I really, really do. If you're using scholar.google and you want to save yourself lots and lots of time, I would work with an attorney and say, how do I best use scholar.google? Because the biggest challenge I run into is, how do I know if the case I'm researching is the most updated case? Like, how do I know that this is the controlling case? It's so frustrating when you cite a case and then you find out that there was another case that came 6 months after it that prevails, and you're in the case that you've invested so much time into is no longer the prevailing case. Like, that is so freaking annoying, and it's such a headache. So, and I've written a bunch of briefs before, and I've run into these frustrations, and in retrospect, I would hire an attorney for an hour and say, how do I best utilize scholar.google.com? So that's the short answer for that question. I personally don't have a good system. And another thing you can do is get Ron and Sherry Palmer's book, Not in the Child's Best Interest, and use those cases and use scholar.google of those cases in your state. So I live in Connecticut. Let's just say, like, one of my favorite cases is Stanley versus Illinois. Love that case. That's the case that elevated unmarried fathers to married mothers. So if you're an unmarried father, you have the same rights as a married mother, as long as you sign the birth certificate and take part in the rearing of your child. So if you live in California and your child was born in Florida and you've never met your child, that doesn't apply. But if you are unmarried and you're male and you've been cohabiting with the mother, or not, just if you've spent time with your child, you are automatically at the same level legally as a married mother, which is amazing. This is a really, really good case for single dads. And so if I want to find out Stanley versus Illinois, and I want to find out if Connecticut applied that in any recent case, I'll go to scholar.google.com and type in Stanley versus Illinois, Connecticut, and then I'll look for a recent case that also cited that case. And then I'll reference the Connecticut case. So let's just say Foster versus Foster. Use Stanley versus Illinois. I'll reference Foster versus Foster when I'm writing anything for Connecticut. I hope that makes sense. I know that's so ridiculously confusing. Talk to an attorney if you want to get a better opinion. So anyway, I'm going to move on to the next question, and we're going to get into another legal question. And again, this is not legal advice. I have to keep saying that. I know it's annoying, but the last thing I need is some person being like, Monica told me to do it this way. And yeah, so I'm going to sprinkle that crap in there all the time, even though that's annoying. So the question is, I have this one written down actually. So it says here, if a child ages out of the family court, can the other parent file anything? Can child support still be abused when the children are in college? So I like this question. Unfortunately, the answer is yes, because I'm going through it right now with my stepson who's 19. There's still tons of court stuff happening, and my husband's being sued for post-secondary education and all that stuff. So unfortunately, the statutes do allow that, but I want parents to start fighting this stuff. A bunch of New Jersey parents came together to fight this recently in the past 10 years. They did not prevail, but they could have prevailed. They just did some weird hiccup thing in their legal argument. Hang on one second, guys. Okay, so I think they could have prevailed, but they did this one thing that they just didn't do it correctly, and it didn't work. But someone like you can take that case and say, where did these New Jersey fathers or mother, I can't remember if it was moms and dads both, but where did these parents, where did they go wrong? And then just fix that little thing and then refile it don't use it exactly word for word, but take their strategy and repurpose it. Repurpose other people's mistakes. That's the best thing you could do. Honest to God, repurpose other people's mistakes, and don't reinvent the wheel. Just do what someone else almost did but didn't, and you can do it. So what I would do if somebody was coming after me after my son was 18, I would fight back using 14th Amendment statutes, say the state does not go after married parents when their children reach the age of 18. The state doesn't force married parents to pay for their children after 18. Why are you doing it to me because I'm divorced? You're discriminating against me for my marital status. So of course the family court judge is going to say, oh, best interest of the child, blah, blah, blah. And then you could appeal and say the same thing to the appellate court. Hey, why am I being forced to support a child after 18 when my married next door neighbors don't have to do that? Why am I being discriminated against for not being married anymore? And I would just carry that all the way up to the Supreme Court. And you're going to need help. You're going to, I would crowdfund or, do like GoFundMe. Make sure that you hook up with someone who knows how to market and like create fundraisers. Sometimes I see really sketchy looking fundraisers that have really terrible like copywriting and stuff. Find someone who has experience in talking, presenting, someone with a big audience, like, find a big parental rights leader, someone like Mark Ludwig or something, or me, or, and say, can you share my fundraiser? Ask for someone to sponsor you. Find someone who has a cause, has a stake in this game. Another attorney who maybe lost their own children, who take on family law cases and want to, find like a family law attorney warrior. Find other warriors who have big mailing lists. Ned Holstein from the National Parents Organization, talk to them. Like, what's stopping you from like arranging for a 20-minute Zoom call with someone with resources and say, look, can you help me crowdfund for this big case? This is a really important case. This is going to attack, the whole statutes where they go after parents of adult children for ongoing child support and college education. I think that is absolutely freaking ridiculous. My parents didn't pay for my college. I was really mad about it for a long time, but at the same, it's my parents' right to not pay for college. Like, that's their freaking right. Like, nobody can force an adult to support another adult. That's a seizure of property. That's a seizure of their money. It's a violation of the 14th Amendment because they don't make married parents do it. And it's coercion and also it's compelled speech, because if the state is forcing a parent to pay for college for an adult child, what if that parent is philosophically opposed to college? What if they're kind of, into like just not, what if they're anti-public schools? Like, let's just say, like me, and they're against paying for college. They're philosophically opposed. The government can't make you pay for something that you're philosophically opposed to. And a guardian ad litem is another example. If the state is making you pay for the services of a guardian ad litem, the state is forcing you into a contract, and the state is forcing you to adopt a philosophy that you don't agree with, which is a guardian ad litem is a better parent of my child than I am. A guardian ad litem is a better steward of my child's best interest than I am. And so if you're being forced to pay for that, then that's compelled speech, because money has been declared to be a form of speech. So if someone's paying you to represent your own child's best interest and you're philosophically opposed to that, then that's compelled speech, and that's a First Amendment violation. And I would go to the appeals court for that. And in fact, we have 3 parents right now in the appeals court for this very issue in Connecticut, and it's super exciting. They are fighting compelled speech. They're saying that they're philosophically opposed to a guardian ad litem determining what's best for their own child, and they're fighting it, and I think they're gonna do really, really well. So it's super exciting. But yeah, if you're philosophically opposed to college, and the state is making you pay for your kid's college, then that's compelled speech. And I would love to see a parent fight that and get a lot of support, crowdfund, go nuts with it. Don't take on these big cases in a vacuum. Don't isolate yourself, because you want a lot of resources to fight this, because this is a really big thing, and this is how we're going to take down the system. And so this sounds really overwhelming, what I'm sharing, but like, it's also overwhelming to pay for college when you're 60 and don't have the resources to do that. There's parents that are like in their 30s right now with little kids, and you could very well be forced to pay for something that you may not be able to afford to pay, or are philosophically opposed to pay. And all that is by virtue of the fact that you chose to separate from your child's other parent, and that's unconstitutional. So yeah, so do your research, make informed choices on all that. All right, so I'm going to get to my final question. How do you know when you have forgiven your ex? I love this question. This is more my specialty. Like, I'm not an attorney or anything, so I'll answer this question. Okay, so for me, I had to really think about this. Forgiveness is like the boogeyman for a lot of parents. They're afraid to forgive their ex. They're afraid to forgive the system because they think that forgiveness is consent and approval for all the abuse that they've endured. But one of the, I think the best decision I've made is that I decided to forgive my ex. And this was like 8 months after my son was taken. I made that decision because I could tell that I was falling apart. I could tell that I was like, I could tell that I was going to get really sick with an autoimmune disease or depression or something like that. And I was angry and miserable, and I was not sleeping, and I was not eating, and like I was just, everything around me was exploding. So I knew that I had to do something different, and I made the decision to forgive my ex. And that was, I talk about that in episode 3 of my podcast. All I did, everything I did to get there, which took all of 5 minutes. And so for me, I have, this is the thing. When you forgive somebody, what you're really saying is, you're not going to affect me anymore. You're not going to affect me at a cellular level. Your issues are still going to inconvenience my life. I'm still going to be mad at you. I'm still not going to like you. But the issues that you're putting in my life are going to stay here. They're going to stay in like a 6 to 12 inch diameter of me. They're not going to get to me here. They're not going to impact me at a, your issues are not going to eat away at my organs and my tissues and my cells. Your nastiness and your abusiveness is going to stay here in my, it's still in my immediate environment, but it's not impacting me here. And so with my ex, my ex is taking me back to court in a couple weeks, supposedly. And I don't really care. It's kind of inconvenient. It's kind of this thing that's here, but it's not in here. It's not inside my body. It doesn't impact the way I think, the way I feel. It doesn't impact my day. And it's just like a little annoying thing that I have to deal with. So when you forgive somebody, you're really just kind of moving their issues outside of your body, and it's not impacting you anymore. And to me, that's what forgiveness is. And so, and it can mean something different for you. And with me, I've also decided to forgive the entire court system as well, past, present, and future judges. So any judge that comes into my orbit who screws me over, I've already forgiven them in advance. And that is simply because I don't want to be miserable. These people do not have any authority to mess up my life. I have already had my life messed up by them for the first couple years, and it's just, they don't get to do that anymore. It's just, they just don't. They're not important enough. And so the way I like to classify these people is, think of a hurricane. A hurricane, a forest fire, an earthquake, that could really destroy your life, right? Think about it. What if an earthquake hit your house tonight and you lost everything? That would really, really, really mess up your life a lot. And so that's kind of how I see the family court system. I see the family court system as a hurricane. My ex is a hurricane. And if and when the system comes and ruins my life and shakes up my whole existence, I'm not going to hold it inside me how bad that earthquake was, I'm going to be like, oh, that was a natural disaster. Your ex is a natural disaster. Your judge is a natural disaster. And so you're not going to take it. First of all, I don't take any of this personally. And understanding the business model of family law has really helped me heal. And I think the best video I've ever made was talking about the business model of family law. It's such an insightful video. It's actually on my main website page, and I will paste it. I'll put the link to that in the description here if anyone wants to watch it. But learning the business model of family law has allowed me to not take any of this personally. Like, all the lies in my case, all the things that are on Google about me that the judge published, three different judges published 3 different sets of lies about me, and I don't take any of it personally. I just don't care. Like, it doesn't bother me because they're only doing it because that's part of the business model. So it's almost like if a hurricane comes and like, a tree falls on my house, I'm not going to take that personally. That's just what hurricanes do. And if it didn't affect my next door neighbor the same way, I'm not going to be like, why did that person get a better deal than me? That's not fair. Like, I don't care. It's not going to impact me. I just keep my own inner resources intact. My health, my mindset, my happiness. I keep all of that intact, and nothing else is allowed to come and knock that down. So it's kind of like a hurricane. Like, you do your best to weatherproof your home. You buy insurance, you buy flood insurance, and you have if you live in an area where you're likely to get hit with a hurricane, you kind of sort of have a plan B in the back of your head. So that way, when things do go down, you can move forward in your life. So that's kind of how I see forgiveness. Forgiveness is just letting go and making a decision that this person can't affect you anymore. And they can't. And once you make that decision, your ex will not affect you anymore. Your ex is the least important person in your case. My ex is the least important person in my case. Just because he's the little, foot soldier that files that initial motion to bring me to court, that means nothing. It doesn't matter. There's nothing that he can possibly do to me ever to really hurt me. So, and that's really what forgiveness is just insulating yourself from their toxicity and just keeping it outside of your body so that you just have to deal with the problems, but it's not internal. So, I hope that helped. I know that's a weird philosophical answer, but I had to really think about that question. So I don't see any other questions coming up, but we did go probably almost an hour. So I really hope that you enjoyed this Q&A session. And if you have other questions, do send them in. I will do another Q&A in about a month or so, and we will catch up next week. All right. I hope you all have a good night. Bye-bye.